Hello friends, today in the third session of evidence, I will start from chapter 2. Section 5. Evidence may be given of facts in issue and relevant facts. Read with me. Evidence may be given in any suit or proceeding of the existence or non-existence of every fact in issue or of such other facts as are hereinafter declared to be relevant and of no others. So what is the meaning of this section? I am again reading part by part. Evidence may be given in any suit or proceedings. So we discussed it in earlier episodes that evidence can be given in any suit or proceedings of the existence or non-existence of every fact in issue and such other facts as are hereinafter declared to be relevant and no others. So evidence can be given only in a suit or proceedings, and on what matters evidence can be given? Evidence can be given only on facts in issue or other relevant facts as described hereinafter. This means in the other chapters of the Evidence Act. Here is one explanation. This section shall not enable any person to give evidence of a fact which he is disentitled to prove by any provision of law for the time being in force relating to civil procedure. What is the meaning of disentitlement? Here comes the matter of conclusive proof. If in any provision there is any conclusive proof, then neither party will be allowed to give any evidence on such fact in issue or relevant fact if it is conclusive proof. Now, before going to the illustrations, I want to discuss the principle based on which this section 5 has been enacted. The principle is res gesti. Section 5 is based on the principle res gesti. Though in the Evidence Act the word res gesti has not been mentioned in anywhere. But what is that? We should know. The principle on which this section is based is the English law doctrine of res gesti, though the section does not expressly make a mention of the term res gesti. The phrase res gesti is a Latin phrase which literally means things done, and in English equivalent is things said or done in the course of a transaction. And the doctrine of res gesti says that when in any suit or proceeding a transaction is the fact in issue, then in such suit or proceeding evidence may be given of every fact which forms a part of that transaction. So basically section 5 is based on the doctrine of res gesti. In LLB exam or in judicial service exam, there you may get question short notes on res gesti. For writing short notes on res gesti, you have to explain the principle, the doctrine of res gesti, as well as the application of res gesti in Indian laws. That means section 5 of the Evidence Act. I think I could make it clear to all of the students. Now, illustrations of section 5. I want to remind you that every illustrations are very much important because you will get questions from these illustrations. So you have to read and study the illustrations very carefully, very minutely. Illustration A. A is tried for murder of B by hitting him with a club with the intention of causing his death. At A's trial, the following facts are in issue. What are that? A is beating B with the club. Next, A is causing B's death by such hitting. And next, A's intention to cause B's death. These three things are facts in issue. When A is tried for the murder of B by beating him with a club, then the facts and issue are A is beating B with the club, A is causing B's death by such beating with the club, and A's intention to cause B's death. All these things are facts in issue. Illustration B. A suitor does not bring with him and have in readiness for production at the first hearing of the case a bond on which he relies. This illustration is basically connected to civil cases. A suitor does not bring with him and have in readiness for production at the first hearing of the case a bond on which he relies. This section does not enable him to produce the bond or prove its contents at a subsequent stage of the proceedings otherwise than in accordance with the conditions prescribed by the CPC. If at the first instance the suitor fails to produce it, then he will not be allowed to produce it in future unless and otherwise it is provided by the law. This is basically related to civil cases. Section 6. Relevancy of facts forming part of same transaction. The previous one is evidence may be given of facts in issue and relevant facts. Section 6 is relevancy of facts forming part of same transaction. A particular transaction may be constituted by several transactions. I am reading the section first. Facts which, though not in issue, are so connected with the facts in issue as to form the part of the same transaction are relevant, whether they occurred at the same time and place or at different times and place. A murdered B by hitting B by a club. This is one transaction. Another incident, A 1 hour before of the incident purchased the club from Mr. Ram's store. Though this is not at the same time and same place, but this is relevant. Why? The club by which A hits B was purchased by A 1 hour before the incident from Mr. Ram. So this is part of the same transaction. This transaction will be treated as part of the same transaction. Illustrations, very important. A is accused of murder of B by beating him. A is accused of murder of B by beating him. Whatever was said or done by A or B or by the bystanders at the beating or so shortly before or after it as to form the part of the same transaction is a relevant fact. Whatever act A threatened B just before the incident, A threatened B that I will kill you, I will murder you. Part of the same transaction. At the time of the incident, there was few peoples. While A was beating B, out of the crowd, Mr. Ram shouted, "Hey, don't do it! Hey, don't do it!" This is part of the same transaction. Illustration B. A is accused of waging war against the government of India by taking part in an armed insurrection in which property is destroyed, shops are attacked, and ghouls are broken open. The occurrence of these facts is relevant as forming part of the general transaction, though A may not have been present at all of them. The initiation has been done by A, and once A has initiated the war against government, the agitated people did all these things, attacked police, attacked government officials, attacked government offices, attacks various defense vehicles, destroyed many things. These things have not been done by A, but these incidents was caused by the people who were instigated by A to wage war against the government. So, though A is personally not involved in all these incidents, but these are relevant. Number C. A sues B for a libel contained in a letter forming part of a correspondence. Letters between the parties relating to the suit out of which the libel arose and forming part of the correspondence in which it is contained are relevant facts, though they do not contain the libel itself. Very nice example to understand the provision. I am reading again very slowly. A sues B for a libel contained in a letter forming part of a correspondence. The letter between the parties relating to the subject out of which the libel arose and forming part of the correspondence in which it is contained are relevant facts. A 5-page letter. The letter is basically a business correspondence. A's company gets 5 lakhs from B's company, and now B is delaying the payment. A has sent one 5-page letter demanding the money, and in this letter, say in paragraph number 5, A has written some libelous words or sentences. So, the letter itself is relevant, though the entire letter is not libelous. The situation out of which the entire letter was written is relevant, though the entire situation is not libelous. Only the few words or few sentences in paragraph number 5 of the particular letter are libelous, but the entire thing, the entire letter, the entire contents of the letter, and the situation based on which the letter was issued, all these are relevant. Illustration D. The question is whether certain goods ordered from B were delivered to A. The goods were delivered to several intermediate persons successively. Each delivery is a relevant fact. Say I ordered some coconut from Kerala. There are several persons. I placed the order directly to the coconut supplier of the Kerala. The supplier will first hand it over to the packer. Packer, after packaging the entire order, will hand it over to courier. Courier, after picking up the order from Kerala, will first come to Bangalore. It will be entered in the record in Bangalore that the shipment has arrived Bangalore. From Bangalore it will come to Chennai. It will be entered in the record. Package has arrived in Chennai. From Chennai it will directly come to Kolkata and it will be entered. And from Kolkata another agency will deliver it to my place. So all the intermediate transactions from the supplier to packer, packer to courier, first courier dispatched, dropped the item to at Bangalore. From Bangalore another courier picked it up and dropped it in Chennai. From Chennai another courier picked it up and dropped it in Kolkata. And in Kolkata another courier picked up the entire shipment and delivered it to my place. So all these intermediate transactions are relevant where my order to Mr. A in Kerala and his delivery of the entire shipment to me. Though these intermediate persons are not have got no role in the order. I place the order directly to Mr. A in Kerala and he is sending the shipment to me. Now I am coming to section 7. Facts which are occasion, cause or effect of fact in issue. Facts which are the occasion, cause or effect, immediate or otherwise, of relevant fact or fact in issue, or which constitute the state of things under which they happened or which afforded an opportunity for their occurrence or transaction are relevant. So, fact which are the occasion, based on which situation A murdered B, cause or effect. What is the cause of A's such grave intention to murder B, and based on which cause or based on which situation A blew the club on the B's head, and what is the effect of that blow, immediately or otherwise, instant effect or effect after 3 days. Instant effect, A blew the club and B died. Otherwise, effect after few days. After the blow, B was seriously injured, was admitted to hospital with serious bleeding injury, and after 3 days, B died. All these are relevant fact or connected to the relevant fact or fact in issue, or these constitute state of things under which they happened. These incidents describes the situation, the entire situation for a particular transaction. The basic transaction is A murdered B. This is the basic transaction. But all these incidents, altercation between A and B, altercation reached to an extreme point between A and B. Suddenly A ran to a tea stall and took out a club and was shouting, I will kill you towards B. Blew the club on B's head seriously with all the forces. B received serious bleeding injury, and immediately or after 3 days or 4 days in a hospital, B died. All these constitute the state of things under which they happened. Which happened? They means who? If I question, in this case, A murdered B, the blow of club, A blew the club on B's head. Under which situation? Under the situation of extreme altercation between A and B. A had no club in his hand in the very beginning. How did he got it? He obtained the club from a nearby tea stall. So all these are things which explain the fact in issue or relevant fact. So these are the occasions, cause or effect of facts in issue. These will be relevant. I think I could make it clear to all of you. If you have any questions, you can directly email me. Illustrations. The question is whether A robbed B. The fact that shortly before the robbery, B went to a fair with money in his possession and that he showed it or mentioned the fact that he had it to third persons are relevant. Question is very simple, whether A robbed B or not. But what are relevant? That B had been to a fair. When B was in fair, B had a lot of money in his pocket. And in that fair, B had shown that money to a third person. All these are relevant to the very small question whether A robbed B or not. Illustration B. The question is whether A murdered B. Marks on the ground produced by a struggle at or near the place where the murder was committed are relevant facts. I want to give you a very simple example. You will understand the entire matter very easily. In a rape case, when the rape took place forcibly, not an allegation of consensual sex. Normally, we check if there is any injury mark on the back of the victim. Because in a rape case, there will be a struggle, there will be some shots of application of force by the accused upon the victim, and the victim will suffer some sorts of injury on her back. This is relevant. Illustration C. The question is whether A person B. The state of B's health before the symptoms ascribed to person and habits of B known to A, which afforded an opportunity for administration of poison, are relevant facts. A murdered B by applying poison to B. Very nice. Now, the B had a habit of taking some liquor before dinner, and after 3 or 4 pegs, B used to go beyond control, and this particular fact was known to A. And taking this opportunity, A applied the poison to B with the liquor. So the habit of B, the situation of out of control of B after 3 or 4 pegs of liquor, all these are relevant. I think I could make clear up to section 7. Now, this is the last section of today's discussion. Very, very important and interesting also. Section 8, motive, preparation and previous or subsequent conduct. Any fact is relevant which shows or constitutes a motive or preparation for any fact in issue or relevant fact. I think before proceeding with this section, I should say something about the term motive. Motive means a reason for doing something. Why I am doing any job, whether good or bad, there must be some motive. There must be some reason. That particular reason is called motive. So we can say that the reason behind the act or conduct or an act to be achieved in doing an act is motive. You will get short notes on motive in your judicial exams. The motive is itself is not an incriminating circumstances and cannot be used in place of proof. Motive cannot substitute a proof, but motive is a supplement. A thing to be noted here that is that the motive is different from intention, because intention refers to the immediate consequences and motive means ultimate purpose. Intention is immediate consequences and motive is ultimate purpose. Note it. Intention and motive are not the same meaning, do not bear the same meaning. They are different in the eye of law for us, for the law students. Intention is the immediate effect, immediate consequences, and motive is the ultimate purpose in which an act is done. So an act may be done with bad intention but with a good motive. My intention may be bad, but motive may be good. Immediate consequences, I know that the immediate operation in your hand will give you pain. And with that intention, I know, with the knowledge that my operation will give you a pain in your hand, I operated. But the motive is good. Motive is to cure your hand's problem. Hence, the evidence of the existence of a motive for the crime charged is admissible in court. Motive is admissible in court. Now I am coming back to section 8. Any fact is relevant which shows or constitutes a motive or preparation for any fact in issue or relevant fact. Any fact is relevant which shows or constitutes the motive, or preparation for any fact in issue or relevant fact. Either it will constitute a motive or it will show the preparation of fact in issue or relevant fact. The conduct of any party or of any agent to any party to any suit or proceeding in reference to such suit or proceeding or in reference to any fact in issue therein or relevant thereto, and the conduct of any person an offense against whom is the subject of any proceeding is relevant. I am reading it again, very confusing but very interesting. The conduct of any party or of any agent to any party, conduct of me or conduct of my agent to any suit or proceeding in reference to such suit or proceeding, that means conduct, my conduct or my agent's conduct in connection to any suit or proceeding in reference to such suit or proceeding means conduct in reference to such suit or proceeding or in reference to any fact in issue therein or relevant fact means conduct should be connected to suit or proceeding. Conduct should be connected to fact in issue or relevant fact, and conduct of any person and the conduct of any person an offense against whom is the subject of any proceedings. Conduct of any person an offense against whom means the victim, who is a subject of the proceeding, is relevant. So if I am the victim, my conduct is also relevant. I have instigated A. You are saying you are going to kill me. Impossible. Mr. A, you cannot. You can do anything to me. All these words are instigating. I am instigating A. These are relevant. If such conduct influences or is influenced by any fact in issue or relevant fact, and whether it was previous or subsequent thereto. Explanation 1. The word conduct, note it. The word conduct in this section does not include statement unless those statements accompany and explain acts other than statements. But this explanation is not to affect the relevancy of statements under any other section of this act. So, the word conduct in this section does not include statements unless those statements accompany and explain acts other than statements. But this explanation is not to affect the relevancy of statements under any other section of this act. Explanation B. When the conduct of any person is relevant, any statement made to him or in his presence and hearing which affects such conduct is relevant. Understand part by part. When the conduct of any person is relevant, my conduct is relevant. Any statement made to him, any statement made to me, or in his presence and hearing. In my presence, a statement is made by someone, not to me, but to some other. But I could hear that, which affects such conduct. The statement made by third party addressing to any third party in my presence, which I could hear. And such hearing, such statement affects my conduct is relevant. In A's presence, in front of A, I told C that A is a bastard. A heard that. I know that A could be able to hear it. And on hearing this particular word, A grew furious. That means this particular word affected the conduct of A. So this is relevant. Though I didn't tell anything to A, I told to C. I am a third party. I told to C who is a third party. But my words to a third party affected the conduct of A unless and until I uttered that particular slang to C in respect of A would be peaceful. But on hearing that, A became furious. So this is relevant. Lots of illustrations are there under section 8. I am reading one by one, but in a little bit fast. A is tried for murder of B. The facts that A murdered C, that B knew that A had murdered C, and that B had tried to extort money from A by threatening to make his knowledge public are relevant. Attempt for extortion of money with the knowledge, due to which A did the second murder, is the relevant. A sues B upon a bond of payment of money. B denies the making of the bond. The fact that at the time when the bond was alleged to be made, B required money for a particular purpose is relevant. At the time of the operation of B's mother, B was in dire need of money. For the purpose of operation, B needed 2 lakhs. And the bond shows that B took rupees 2 lakhs from A. And time is same, just before the date of operation. So in this suit, the requirement of B is relevant. C. A is tried for murder of B by poison. The fact that before the death of B, A procured poison similar to that which was administered to B is relevant. Very easy. Very easy. No need to further discuss it. I am directly coming to D. The question is whether a certain document is the will of A. The fact that not long before the date of the alleged will, A made inquiry into matters to which provisions of alleged will relate. A made inquiry how to make a will, who can make a will, whether a will is required to be registered or not, whether there is a need to pay stamp duty or not. A made various types of inquiries related to will. That he had consulted vehicles in reference to making the will, and that he caused drafts of other wills to be prepared of which he did not approve are relevant. E. A is accused of a crime. The fact that either before or at the time of or after the alleged crime, A provided evidence which would tend to give the facts of the case an appearance favorable to himself, or that he destroyed or concealed evidence, prevented the presence or procured the absence of persons who might have been witnesses or suborned persons to give false evidence respecting it are relevant. A is accused of a crime. The fact that either before or at the time of or after the alleged crime, A provided evidence which would tend to give to the fact of the case an appearance favorable to him, or that he destroyed or concealed any evidence, or prevented the presence or procurement, the absence of persons who might have been witnesses, or suborned persons to give false evidence respecting it, are relevant. So every subsequent act are relevant. F. The question is whether A robbed B. The fact that after B was robbed, C said in A's presence, the police are coming to look for the man who robbed B, and immediately afterwards A ran away, are relevant. I think these are not required further explanations. The question is whether A owes B rupees 10,000. The fact that A asked C to lend him and that D said to C in A's presence and hearing, I advise you not to trust A, for he owes B 10,000 rupees, and that A went away without making any answer, are relevant. H. The question is whether A committed a crime. The fact that A absconded after receiving a letter warning him that inquiry was being made for the criminal and the contents of the letter are relevant. So fleeing of A after receiving the letter and the contents of the letter, both are relevant. The question is whether A was ravished. The fact that shortly after the alleged rape, she made a complaint relating to the crime, the circumstances under which and the terms in which the complaint was made are relevant. The circumstances under which the complaint was made and the terms in which the complaint was made, both are relevant. The fact that without making a complaint, she said that she had been ravished is not relevant, as conduct under this section, though it may be relevant as a dying declaration under section 32 clause J or as corroborative evidence under section 157. We will discuss this point at the time of discussing section 32 and section 157. The question is whether A was robbed. The fact that soon after the alleged robbery, he made a complaint relating to the offense, the circumstances under which the terms in which the complaint was made are relevant. The circumstances, that is relevant. The terms of the complaint are relevant. So, today we discussed up to section 8. In the next session, we will start from section 9. Till that time, I will advise everyone to go through the sections thoroughly, read it thoroughly and thoroughly. And if you have any question, any doubt, please don't hesitate to write to me in the email ID available on your screen. And if you have any advice for development of these lecture sessions, please do not hesitate to share your advices, feedback. And if you like my videos, I will request you to please share. Thank you. Stay safe.